So welcome back, dear students. Today we are going to learn the drafting of an application for compounding of offences by way of compromise under section 320 clause 1 of CRPC. Dear students, so far as compounding of offences is concerned, section 320 of CRPC provides for compounding of certain offences. Compounding may be done with the permission of the court, and compounding can also be done without permission of the court. There are two lists in section 320 of CRPC. The first list, offences which are mentioned in the first list, can be compounded with the consent of the complainant who lodged the criminal case, but without permission of the court. We have a second list also in section 320. The offences mentioned in second list can be compounded with the consent of the complainant who lodged the FIR or complaint, but with the permission of the court. The offences mentioned in list 2 are slightly more serious in nature as compared to list 1. And dear students, you know that normally the concept of negotiable settlement in criminal cases is not permissible in Indian legal system, as it was held in state of UP versus Chandrika, the case decided by the Supreme Court in 2000. This concept of alternative dispute resolution in criminal law was, however, introduced in CRPC in 2006, where the chapter of plea bargaining was added in CRPC by CRPC Amendment Act number 2 of 2006 with effect from 5th July 2006, and section 265 capital A to 265 capital L were added in CRPC. Likewise, I told you that there are two tables in section 320 of CRPC. The offences punishable under various sections of IPC specified in first two columns of first table can be compounded by the persons mentioned in the third column of the table. So the offences mentioned in the first table are comparatively less serious in nature, hence they can be compounded without permission of the court. Similarly, the offences punishable under various sections of IPC, which are specified in the first two columns of second table, can be compounded with the permission of the court, before which any prosecution for such offence is pending. And they may be compounded by the persons mentioned in the third column of the table. And if the offence is compoundable, then its abetment or attempt may also be compounded in the like manner. This is the mandate of section 320 clause 3 of CRPC. And if the accused is committed to the court of sessions when he has been convicted and appeal is pending, then no composition of the offence shall be allowed without the leave of the court to which he is committed or before which the appeal is heard. So it is the permission of the appellate court now. With the permission of appellate court, the offence can be compounded. The High Court or Court of Sessions, while hearing revision under section 401 of CRPC, may also allow any person to compound any offence which such person is competent to compound under this section. There are exceptions also. The first exception is that if by reason of previous conviction, a person is liable to enhanced punishment, such offence shall not be compounded. This is the mandate of section 320 clause 7 of CRPC, that if by reason of previous conviction, a person is liable to enhanced punishment, then such offense shall not be compoundable. And dear students, once the offense is compounded, the result of compounding is acquittal. The composition of an offense under section 320 of CRPC shall have the effect of acquittal of the accused with whom the offense has been compounded. And dear students, you must take care that this list of compoundable offenses is exhaustive and no offense shall be compounded except as provided in section 320 CRPC. And dear students, before dwelling upon the actual drafting of an application for compounding, you should know the distinction between compounding and withdrawal of a case. There is a clear-cut distinction between compounding and withdrawal of a case. Application for withdrawal of a criminal case can be moved by public prosecutor or assistant public prosecutor in charge of the case, and the case may be withdrawn with the consent of the court at any time before the judgment is pronounced. This is section 321 of CRPC, that before judgment, PPP, PP or APP can move an application for withdrawal of the case. And so far as effect of withdrawal is concerned, if the withdrawal of the case is made before framing of the charge, then accused shall be discharged. And if the withdrawal is made after framing of the charge, then accused shall be acquitted. Whereas in compounding, the result is always acquittal of the accused. In UP, there is an amendment that written permission of the state government for withdrawal of the case is also required to be filed in court before PP or APP moves an application for withdrawal of a criminal case. He has to annex the written permission of the state government. And there is no separate list of cases which can be withdrawn as opposed to two lists contained in section 320 of CRPC. That means all offenses can be withdrawn by the state government. Even the cases of murder can be withdrawn at the discretion of the state government. Now, dear students, with this background knowledge in mind, let us start drafting of an application for compounding of offenses under section 320 clause 1 of CRPC. Clause 1 means where no permission of the court is required, the case can be compounded with the consent of the complainant or the person who has set the criminal law into motion. And dear students, as usual, in every drafting, you will have to select the name of the court first. So in this illustration, the name of the court is before the Metropolitan Magistrate Saket at New Delhi. Criminal case number, you know, because case is already pending. Say, for example, it is case number 1234 of 2017. Name parties, you know, State of NCT of Delhi versus number 1A, number 2B, number 3C. There are three accused persons, and you will have to mention under which sections the case is pending. So it is under section 323, 324 upon 34 IPC. And you will have to write down the name of the police station also. So here PS Saket and FIR number 3 of 2017. Center heading will be application for compounding of offense under section 320 clause 1 of CRPC. The beginning may be done like this. May it please your honor, the complainant and the accused persons herein before beg to submit as under para 1, that on the information of the complainant, the police had registered a case against the said accused persons. Police investigated the case and filed the charge sheet against the said accused persons under section 323, 324 of IPC 1860. Para 2, that the complainant and the accused herein before have decided that they shall forego the past incident and would restore their old friendship and would continue their amicable relationship. Para 3. That complainant therefore is not desirous of pursuing with this complaint against the said accused persons. Para 4. That offences alleged to have been committed by the said accused are compoundable with the complainant with the consent of the complainant. Para 5. It is therefore most humbly prayed that the Honorable Court may be pleased to allow this application of the complainant for the compounding of said offences and be pleased to dispose of the case as compounded, and the said accused may kindly be acquitted. And for this act of kindness, the applicants as duty bound shall ever pray for. Then you will mention the place where this application was drafted, then date, 1st day of January 2017. Signature of PQ or complainant are required on this application, and signature of ABC accused persons are also required on this application, meaning thereby that this application for compounding of offense shall be presented jointly by the complainant and accused persons. And since this application has been drafted by some advocate, so you will mention that presented through XYZ advocate for the complainant, and the signature of the counsel for complainant shall also be appended on this application for compounding of offenses. Now, dear students, the second item which I wish to cover today is drafting of an application under section 482 of CRPC. 482 of CRPC deals with saving of inherent powers of the High Court, and its language is that nothing in CRPC shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order or to prevent abuse of process of any court or otherwise to secure the ends of justice. And it is well settled that inherent powers under section 482 can be exercised only and only when no other remedy is available. I have highlighted this portion: when no other remedy is available to the litigant. The inherent power should not be exercised where a specific remedy is provided by law. The powers under section 482 of CRPC are extraordinary one, hence these powers should be exercised very sparingly. Supreme Court decided in Dhan Lakshmi versus R. Prasanna Kumar that to prevent the abuse of process of the court, High Court in exercise of its inherent powers under section 482 could quash the criminal proceedings if complaint did not disclose any offense or that the complaint was frivolous, vexatious, or oppressive. Another case, State of UP through CBI Lucknow versus R.K. Srivastava, was decided by the Supreme Court in 1989, wherein it was held that if the allegations made in the FIR taken at their face value and accepted in their entirety do not constitute any offense, then criminal proceedings on the basis of FIR should be quashed under section 482 of CRPC. We have another case, State of Bihar versus Murad Ali Khan, 1989 decision from the Supreme Court, and it was held that while exercising jurisdiction under section 482, High Court will not embark upon an inquiry whether allegations in the FIR or complaint are likely to be established by evidence or not. It is not to be seen. The allegations may be proved by evidence or may not be proved by evidence. This is not to be seen in 482. And very important case, Lalu Prasad Yadav versus State of Bihar. This was decided by Patna High Court. In this case, it was held that it amounts to abuse of process of the court if without prima facie case having been made out, a person is summoned to face trial in criminal proceedings. The Chief Minister of Bihar and another were summoned under section 500, 501, 502, and 504 of IPC. A complaint was filed against Chief Minister of Bihar, Mr. Lalu Prasad Yadav, and another. And it was alleged in the complaint that a news item was published in Hindustan Times in which Lalu Prasad Yadav was attributed with utterance of a word kukur. Kukur means dog. Kukur for the Kori and Kurmi castes. It was alleged that by publication of said news, the complainant and his caste have been lowered down in the esteem of the society, and they have been defamed, and it has caused mental agony to them as well. Now, Lalu Prasad Yadav and editor of the newspaper, they were summoned by the court after examining the complainant and 4 witnesses. None of the witnesses supported the version that the present petitioner uttered the said words in the presence of others. There was no proof, and the petitioner got a contradiction published in the various newspapers denying the uttering of objectionable words. Thus, in the opinion of the High Court, no prima facie case against Lalu Prasad Yadav was made out so as to summon him to face the trial. Thus, taking cognizance against Lalu Prasad Yadav was bad in law and abuse of process of the court, inasmuch as a person was summoned to face a trial in a criminal proceeding without a prima facie case being made out against him. Thus, the order of taking cognizance was set aside by the Patna High Court under section 482 of CRPC. Now, dear students, with this much background knowledge in mind as to what is section 482 of CRPC and what is the spirit behind section 482 of CRPC, now we will start the drafting of an application, drafting of a petition under section 482 of CRPC. So first of all, you will have to select the name of the court. As you know that this jurisdiction belongs only to the High Court. So you will choose the name of the High Court. In the present illustration, the name of the court chosen is in the High Court of Judicature at Allahabad. Criminal petition number dash dash of 2017 in case crime number dash dash of 2016, which is already pending before some lower court. And this case is pending between A son of B, who is the petitioner, and opposite party is state of UP, and X son of Y, resident of 52 Lajpat Nagar, New Delhi. They are our respondents. Now the center heading will be drafted like this: petition for quashing criminal proceedings. You will write down in the bracket under section 482 of CRPC 1973. And the beginning of the petition is to be drafted like this: before Honorable the Chief Justice and all the companion judges of the Honorable Court, the above named petitioner or accused most humbly submits as under. Para 1. Now you will write down the facts. Para 1. The petitioner accused has been arraigned as accused in criminal case number 27 of 2016 on the file of Chief Judicial Magistrate Noida, District Gautam Buddha Nagar. Case number is 27 of 2016. All right. Para 2. It is humbly submitted that X son of Y had filed a complaint case against the petitioner accused under section 138/142 of the Negotiable Instrument Act 1881 on the ground that the check issued by the petitioner accused in question towards the payment of goods supplied by the complainant was bounced, and the payment thereunder was not made in spite of issue of requisite legal notice. The complainant has also filed an FIR under section 420 of IPC, which is registered as FIR number 2 of 2016 at police station sector 62 Noida, District Gautam Buddha Nagar, UP, and investigation for the same is pending but the police is harassing the petitioner. Para 3. It is humbly submitted that the complainant has filed a said criminal complaint case in haste and in spite of assurance of the petitioner that the payment in question will be made in due course. Para 4. It is humbly submitted that the petitioner accused has received the legal notice on 2nd January 2016 and the complaint case was filed on 2nd January 2016 itself, and FIR was also filed next day on 3rd January 2016 in connivance with the police. Para 5. It is humbly submitted that complaint case as well as FIR was filed well before arising of cause of action under Negotiable Instrument Act, and as such, taking cognizance of such a premature complaint by the learned trial court is illegal and unconstitutional. Para 6. It is humbly submitted that the petitioner cannot be put to double jeopardy inasmuch as he has to face a complaint case as well as a charge sheet, if any, to be filed by the police under Section 173 of CRPC. The Chief Judicial Magistrate has already issued summons for the appearance of the accused petitioner in his court. Para 7. It is most respectfully submitted that mandatory provisions of Section 138 and 142 of the Negotiable Instrument Act 1881 were not followed by the learned lower court. And Para 8. It is also submitted that the complaint filed before the learned lower court was premature in view of 15 days time period available to the petitioner for making payment under Section 138 Clause C of Negotiable Instrument Act. Para 9. It is humbly submitted that the proceedings pending before the learned lower court are liable to be quashed inter alia for all or any of the grounds mentioned above. Under the circumstances, it is humbly prayed. Now, this is the prayer clause A, that this honorable court may be pleased to quash the proceedings in criminal case number 27 of 2016 on the file of CGM Noida, Gautam Buddha Nagar, UP, and to pass such other or further order or orders as this honorable court may deem fit and proper in the facts and circumstances of the case. And B relief is that pending disposal of this petition, it is humbly prayed that this honorable court may be pleased to stay all further proceedings in criminal case number 27 of 2016 on the file of CGM Noida, District Gautam Buddha Nagar, UP, and to pass such other or further order or orders as this honorable court may deem fit and proper in the facts and circumstances of the case. Then you will mention the place, Allahabad, date 2nd January 2017. The petitioner will put his signatures on this petition, and since this petition has been drafted by some advocate, he will also append his signatures to this application, and you will write down the name XYZ counsel for the petitioner. So dear students, you know that under Negotiable Instrument Act, only complaint case can be filed. FIR is not allowed to be filed in check bounce cases, and in complaint case also, the defaulter has a 15 days time for payment after receipt of the notice from the complainant. Here in this case, this mandatory period of 15 days was not allowed to the accused person. The FIR was lodged the next day and complaint case was lodged on the same day when notice was sent. So it is a good case wherein Honorable High Court can quash the complaint case proceedings pending in the court of CGM Noida.